As the court pleases, my lady. Thank you. It's
Mr. Machadla, I see that the applicant appears to have joined the platform. Is that correct?
Yes, Judge.
Okay. Then can you, I know I did say stand down to 9:40, but I think if everyone is here, Mr. Mathe is there, Mr. Mathe is there, I think let's resume the hearing. Can you recall the matter?
Recalling the matter of Mjaju Joseph Mathe versus the CCMA case number 2024-035893.
Thank you. Can the applicant please introduce himself?
Hello, it's Mjaju Joseph Mathe, the applicant for the applicant. Thank you.
Thank you, Mr. Mathe. And Mr. Mathe, are you online?
yes, my lady. I still confirm my appearance on behalf of the respondent. Thank you.
Thank you. Mr. Mathe, you may proceed.
Okay, my lady, I would like to bring to the court's attention that the respondent did not give their intention to oppose, nor their notice to abide. They only sent me their heads of argument yesterday. Now, I don't know if heads of argument can be made in a vacuum, because I didn't know their position there. Because since they did.
Yes, Mr. Mathe, in an application for leave to appeal, you're not required to file a notice to oppose or a notice to abide, and the parties are entitled. And in fact, the note that I sent out said that the parties may file heads of argument, not have to, but may file heads of argument. So there is nothing out of procedure in respect of what is transpired. You may consider them properly before this court. Thank you.
Okay. Thank you, my lord. My lady, my grounds are actually quite simple, my lady. It was not in dispute that acting Judge Murkoff did not read the papers filed. The only thing was in dispute was whether the reason why he did not read the papers filed. The respondent claimed that he could not access have access on case lines. But when we were at the court, it's in my affidavit that when we were in court, he did go through case lines and the papers were there. And the second part, my lady, is that the respondent never filed their answering affidavit, and it's not stamped, and it's not compliant with the rules of the court. So it was improper for the court to have relied upon it. And also, my lady, I'm not sure if the answering affidavit you had when you were writing your judgment is the one I had when I was writing my answering affidavit. I have no way of confirming that, because they are not stamped, and so I think it was improper. And my lady, when this is important, because my lady, when things are filed on court online, they are stamped so that one party may not alter the pleading and insert a page there or replace it. That's why it's there. So when it's not stamped now, I'm not sure. I'm doubtful whether you had the same answering affidavit as I had. So I think it was improper. And if what I would like to submit was the proper procedure was first, and I would like to submit that the court had no basis to rely on that answering affidavit, because in our combined in our joint practice note, I did put it there that the respondent did not file their answering affidavit, and the court must exercise its discretion, and the court ignored that point entirely. And also the respondent never asked for condonation, and the pleadings were closed. So what I would like to submit was the correct procedure was that my answering affidavit would stand as it is, or the Plascon Evans rule must apply, which was not also applied, because what was only said in the judgment was simply that the respondents, deponents are officers of the court, and
Mr. Mathe, can I just stop you there?
Yes.
You say in your replying affidavit, under your footnotes, this is what you say. You don't say it wasn't filed. Just bear with me a moment. Under footnote 1 to your replying affidavit, you say the respondent filed their answering affidavit out of time. That is what you're saying under oath. The applicant only condoned the respondent's late filing to finalize the matter. So what you're now saying is that the respondent did not file their answering affidavit. So you saying something that you have that is the opposite of what you've said under oath. In terms of the rules of court, there are very serious consequences if you change a version of events that you've made under oath, and you need to produce reasons as to why you have withdrawn that statement you've made under oath. It's been commissioned by the South African Police Services. Can you speak to me to that point?
Oh, my lady, oh, sorry, I see where your confusion might be. When I was speaking to the late filed affidavit, I was referring to the main application. On the main application, that was what I was addressing. In the main application, they sent their answering affidavit late, and because the matter was on the agent court, I didn't want the agent court to raise to raise technicalities. That's why that paragraph refers to the main application. When you
okay. All right, I see what you're saying. Thank you for that clarification. So where then in your replying affidavit to the answering affidavit do you raise the issue that it has not been filed, or it is filed out of time in this application? I don't see that in your replying affidavit.
My lady, I would like to clarify this properly. My lady, when I was replying to this affidavit, I was replying it in good faith, because I had no reason to doubt the respondent. So I replied to it. But when the hearing was close by and we were going through the pleadings, preparing for the hearing, I saw, and then when we were doing the combined joint practice note, I noticed that they never filed. And then I even said on the joint practice note, the respondent did not file their answering affidavit, and the pleadings have closed, and I cannot object because the pleadings have closed.
But there's an affidavit on case lines that was served on you. There is a proof of service email dated the 7th of May to you to say, in terms of the Uniform Rules of Court, which provides for service of documents and notices to be effected by electronic mail, kindly accept the electronic service. Now, in terms of the rules, that is all that is required. The filing of that affidavit onto the platform doesn't mean that that affidavit is excluded. As long as it is served on you,
My lady, I think that's where we differ. There's a difference between the service. The service is between is for fairness between the parties, but the filing has to do with the court's jurisdiction. If something is not before the court cannot hear things that are not filed properly within the court, my lady. That's why things must be admitted.
Okay. So, Mr. Mathe, I'm looking at the answering affidavit, and according to case lines, it was filed on the 22nd of May, 2025. That is the date that case lines shows me. What are you saying has not been filed?
My lady, case lines is not for filing. Court online is for filing. So you must put the things where in the proper filing platform, which is court online. This is clear even on the directives that the uniform rules still apply. The directive does not replace them. The correct filing platform is court online. Case lines is for constructing the evidence that is already filed, not to file itself, my lady.
But I don't have court online. I see what has been put onto case lines. And you say the respondent filed their answering affidavit on the 19th of May. It was filed on the 22nd of May, 2025. That is the date that case lines shows me. What are you saying has not been filed?
My lady, case lines is not for filing. Court online is for filing. So you must put the things where in the proper filing platform, which is court online. This is clear even on the directives that the uniform rules still apply. The directive does not replace them. The correct filing platform is court online. Case lines is for constructing the evidence that is already filed, not to file itself, my lady.
But I don't have court online. I see what has been put onto case lines. And you say the respondent filed their answering affidavit on the 19th of May, some 10 months after the pleadings have closed. Now, you can't raise this in a joint practice note. You should have raised this in your replying affidavit, because that was not an issue that I needed to determine. So I will hear the respondents on this issue, but prima facie, the judgment was written on the basis that there was a founding affidavit and there was an answering affidavit and there was a replying affidavit. And there was no argument in the replying affidavit dealing with the answering affidavit being out of time. So that wasn't an issue. It was on the platform when the matter was heard in this courtroom. Are there any other submissions on this point you wish to make?
My lady, yes. My lady, I would like to clarify this. My lady, when the respondent sent me their answering affidavit, I had 10 days according to the rules to reply. And I replied within that 10 days. I did not know that they did not file. I only discovered that they did not file when they sent me their practice note. And in my practice note, I even made an error, which was generous to them. The error said that they filed it late in some days last year, but the error was actually even more dire. They never filed at all. That's why if you are on case lines, you will see there's no stamp on the court stamp to prove the filing was done. So it was never filed, and I cannot object after the pleadings have closed, my lady.
Thank you. You may proceed.
And also, my lady, and the other thing, there is also a part. Yes, okay. After the part I would also like to deal with, my lady. One of my grounds for appeal is the rule of law, my lady. The rule of law and Section 34, the right to the access to courts, my lady. My lady, when we come to court, my lady, the Constitution promises us a right that we should not beat people in the streets. Instead, we must come to court, and our dispute must be resolved by an impartial adjudicator, a judge, maybe an arbitrator. But what my case was on the rescission was that I did not go and beat the respondent and do unconstitutional things. I came to court, but the judge decided he was not going to read my pleadings, and he did not read them. And then he gave an order. He gave an order dismissing my application, while he admitted in open court that he did not read the pleadings. So when I made that decision, it was that my Section 34 right was infringed. And secondly, my lady, when my right was infringed, I did the proper procedure on those circumstances was that I received the judgment, so that an appellate court does not become the court of first instance. So, and that's why the rule of law is important. And also on the point of the rule of law, my lady, I think it's very important to everyone that even and everyone is equal to the law, even judges, my lady, so that we must not do wrong things in court and then be penalized. And when judges don't read pleadings, their order stands, my lady. My right was infringed. That's why I took the appropriate recourse. And my other ground, yes, and then my other ground is, my lady. My lady, during the hearing, you requested access to the main application, and then I had my reservations about that, but I just said nothing because the court has inherent jurisdiction to regulate this process. I thought maybe you were going to look into the main application to see what it's about. But upon reading the judgment, I saw that you did not mention the main application. And then the other part is that, my lady, during the hearing, my lady, you did not ask me about the order. You specifically asked the respondent to send you a copy of the order by Moorcroft. And then since you asked them, I thought because they are officers of the court, I must not do things that I'm not asked. And then I waited. After 2 weeks, they did not send the order, but because it was in the interest of justice, I did send the order, and then I put it on case lines, and then I informed your clerk there, and she told me, and she confirmed that she received it, and I even directed her that I put it under final order because it was the only relevant section. And also, my lord, I would like to address you also on the issue of course, my lady. When we were at the hearing, there are things maybe to my detriment that I thought were tried and common cause, that the respondent, my lady, is the state. And since when you are taking the state to court, when it comes to the issue of courts, the BioWatch principle applies. But in this matter, it was not applied. And when it came to the issue of cost, you only asked the respondent to address you, and you did not ask me to address you. So when you did that, I thought in your mind you had the BioWatch principle that since I'm exercising my constitutional right, I must not be punished. As a result, I saw that. But upon reading the judgment, I saw that no, you in fact treated the state as a normal litigant, but they are not, my lady. My lady, I think those are all my submissions on the leave to appeal, if I'm not mistaken, but I think I've covered all 5 of them.
Thank you very much, Mr. Mathe. You can turn off your camera. Mr. Matidza, can you please address me?
As the court pleases, thank you, my lady. My lady, the applicant faces several difficulties in respect of this application for leave to appeal. And the first one, my lady, is that in bringing this application for leave to appeal, the applicant has failed to comply with the rules applicable to appeals, to civil appeals, which is Rule 49, my lady. Now, my lady, we know that the applicant elected to represent himself. But, my lady, even parties who elect to represent themselves, my lady, have to comply with the rules, with the uniform rules of court. Now, in terms of Section 49 of the rules of court, my lady, the applicant was required to file this appeal within 15 days after the date of judgment, which was 5 September 2025. Now, this appeal, this application for leave to appeal was then filed on the 16th of October 2025, which is not within the 15 days. And my lady, we submit that in line with Rule 49, that this court cannot entertain this application for leave to appeal up until it is placed in a position where it can assess the explanation for the delay and decide whether or not the explanation shows any good cause. So, my lady, on that ground, we submit that this court should not entertain this application for leave to appeal up until there is a condonation application before your ladyship and there is a pronouncement on that condonation. Now, my lady, when we go to
Mr.
the
Matidza,
ground...
Mr. Matidza, before we go there, on that point,
yes,
you say the leave to appeal was filed on the 16th of October 2025.
Yes.
Where do I find that on case lines?
My lady will see on the... I'm just going to case lines now.
Because let me explain to you my issue with that.
Yes, yes, my lady.
It says, if I go to the court online cover page for the
apologies.
leave to
7
appeal
October. Yes.
at 11-1, it says the document was filed on 7 October 2025.
7 October, yes, correct.
So,
apologies, my lady.
Okay, so when did the 15 days expire? I haven't done the maths. Have you?
My lady, according to my calculation, it expired on the 29th of September, 2025.
Okay.
Yes, that's according to my calculation. And apologies, my lady, I did miss that. It is indeed 7 October 2025, but it is still late, my lady. It is still out of the 15 days.
Okay.
Yes, my lady.
All right. It's a bit confusing because then it says on the cover page, the time and date the document was filed by the party is presented on the header of each page of this document. And if you look at the header then says 24 September 2025. What must I make of that? If you look at 11-2.
My lady, 11-2 is
you look at the date stamp at the heading. Yeah.
Indeed so, my lady. However, when we have regard to the filing note itself, it says this document was filed on 7 October, my lady.
Okay.
Yes, that is the date that the application was filed, my lady.
All right. Okay. So I think address me on the merits.
As the court
on that, and I will ask Mr. Mathe to address me on this issue of when this document was filed in his reply. Thank you.
as the court pleases. My lady, on the merits or the grounds of appeal, it's our submission that the application still doesn't meet the requirements of Section 16 and Section 17 of the Superior Courts Act. My lady, we outline those issues in our heads of argument, which appear on Section 6 of case lines. And
yes, I have seen the heads of argument and I have read them.
Yes, my lady, I will then be very brief in just outlining each ground of appeal. Now, the first ground of appeal, my lady, is based on the ground that there was a failure to consider material facts and evidence on the basis that Judge Moorcraft did not read the papers. Now, my lady, the difficulty that the applicant has in this regard is that judgment and order of Moorcraft AJ is not under attack. It's not under appeal, my lady, and therefore it still stands. Now, if the applicant was aggrieved, the correct procedure would have been to appeal that decision. So, my lady, we say in respect of this ground that there are no prospects of success, and then the appeal can be dismissed on this ground. Now, there is also a ground, and I heard the applicant was at length trying to explain that there was no answering affidavit which was filed. However, my lady, the fact that the applicant replied to that answering affidavit and further even acknowledged that he condones I think it was late by a day. And we must also consider that that matter was before the urgent court, my lady. So, my lady, according to case lines, according to the replying affidavit, there is a answering affidavit. If there was no answering affidavit, my lady, then there was no need to file a replying affidavit. In that respect, my lady, we also say that ground does not have any prospect of success. There is also the third ground wherein the applicant alleges that there was a mischaracterization of the nature of the rescission application as the court misconstrued the Rule 42 of the application of the Uniform Rules of Court. But my lady, the applicant does not explain in what manner that application or that Rule 42 application was misconstrued. There is also a ground for failure to exercise the judicial discretion, wherein the applicant alleges that the court should have called for the record of proceedings or transcripts in the main application, my lady. However, my lady, again, the applicant says nothing more on how the court should have exercised that discretion or what was the basis that warranted the court to then call for the record. Lastly, my lady, there is a ground of error of law, as a court must deal with the matters in a manner which it deems fit, and it also misconstrued the nature of agency. On this ground, my lady, it is common cause that the variation application was brought on the normal course. It was not brought by way of agency. So, my lady, this ground of appeal is misconstrued and there's no application. My lady, those are our submissions. We submit that there are no prospects of success. There are also no compelling reasons why the application for leave to appeal should be granted, my lady. If one is to have, or if the court is to have regard to the grounds of appeal, my lady, we submit that this appeal should be dismissed and that the costs should follow the cause, my lady. The appeal should be dismissed with costs, my lady. And my lady, I heard the brief discussion on costs that the respondents should not be awarded costs because they are a state institution. My lady, the respondents have been incurring costs in defending or opposing the applications that are brought by the applicant. And in this case, my lady, you would note that even on the grounds that are outlined for application for leave to appeal, there are no constitutional issues raised. And therefore, the bio-watch principle, my lady, we submit that are not applicable in this case, my lady. That is the grounds of opposition from the respondent side, my lady, unless there's anything that my lady would like me to address, my lady, as the court pleases.
Thank you, Mr. Mathe. You also mentioned about the fact that the appeal will not have a practical effect. Just address me on that point.
Indeed so, my lady. My lady, it goes back to the fact that as we're sitting here today, there is a judgment and order which was in the main application. That order still stands, my lady. So even if this court is to grant this leave to appeal, it would be of no practical effect, my lady, because the judgment that was granted or ordered by Mocraft AJ, my lady, is still valid up until such a time it's set aside by a court. So granting leave to appeal, my lady, will not have any practical effect because it will not disturb the operation of the order and judgment of Mocraft AJ, as the court pleases, my lady.
Thank you, Mr. Mathe.
Thank you.
Mr. Mathe, can you give a reply, please?
Yes.
And Mr. Mathe, I think start from the point made by Mr. Mathe that the application for leave to appeal was filed out of time. What do you have to say about that?
Thank you, my lady. My lady, this also helps, also illustrates the difference between filing and service. My lady, when I was drafting the leave to appeal, I saw the time, my lady, and as you might have noticed that the leave to appeal is not the best because it was a race against time. So I did comply with the uniform rules, and I filed with the court within the prescribed time. I think it was on the 29 or 27 when I filed. But the court, the registrar, and the registrar is the court, and the registrar took 2 or 3 weeks for it to finally stamp it and serve it to me. And that's important because, my lady, I was not going to serve the respondent a leave to appeal that is not stamped, that is not filed. So I had to wait for the court to stamp it and then file it. And once it was filed, only then is service required. So I did. If you look at the leave to appeal there, at the bottom there, it has a date there. The date is the date that I filed it with the court, but the court took its time. And I cannot be asked to write a condonation application to explain the court's own delay. It's not my fault that the registrar took their time. And my lady, even when we apply for dates here in this court, you apply for a date in January, nothing is said. You get it the next year, and then when you get it the next year, you don't have to explain why did you wait for this long to sit it down. You did it within the prescribed time. The thing is, the court is not so efficiently to do that. It was not my fault. And my lady, the second part, when it comes to condonation, my lady, condonation is not made in a vacuum. If I did not file within the prescribed time, I would have written a condonation. And when I served the respondent the leave to appeal after it was filed, they did raise this point, and then I sent them a screenshot of the notice when I filed it. They have it there, and if the court would like to see it after the hearing, I can send it to your registrar. That will confirm exactly the date when it was filed within the prescribed time. And yes, I think I've addressed the condonation part. And yes, and then my lady, to reply to the respondent, I would like to clarify this again. My lady, the part in the replying affidavit where I say the the affidavit was filed late, but I condone their non-compliance and whatever. I was doing that at the agent court because they did not file that, because I could not come to the court and say I want agent relief, but the respondent must also ask for condonation. I said nothing, but the judge, despite those things, he did not read the paper. So my lady, when it comes to the relevant sections of the leave to appeal, my lady, I would like to submit that my prospects are great, because if there is no replying affidavit, I cannot be faulted for replying, because my lady, it's not my fault that they did not file, they only served. Because if there is no replying affidavit, the court must exercise its inherent jurisdiction to regulate this process and say the applicant served the respondent his founding affidavit. The respondent then sent him their answering affidavit, and then he replied. But just before the hearing, a year later, the applicant discovered that they never filed. So since they never filed and the pleadings were closed, I could not object because I discovered it late. But what is good about this is that I did not discover this after the judgment. I discovered it before the hearing, and then I put it in the practice note so that because the joint practice note is where the parties come together and say this and try to summarize the case to help the court. We did that, and in that thing we did the joint practice note. It is there that they did not file their answering affidavit, and that point is important because it changes the entire case. Because my lady, the other thing is when I get to the full court or the SCA, I will have to compile the record of the appeal, and when I compile the record of appeal, I will only be allowed to put the things on record that are officially on the court record. If it's not stamped, it's not part of the court record. That's why this point is very important, my lady. So this point is that I cannot be faulted for replying if there is no answering affidavit. It maybe the same logic extends that there's also no replying affidavit, and then the rescission might have been decided on the founding affidavit alone, because one might even say the replying affidavit is the fruits of a poisonous tree, because the answering affidavit is not filed, and then what comes after is also it's unclear where it stands in the law, my lady. And now to reply to the respondent, my lady, this matter raises a serious constitutional point that is of public interest. And this point is that, my lady, judges are not above the law. So they must also do their duty that they took their oath to uphold, that they will administer justice fair, impartial, without favor. Because my complaint in this rescission was that my Section 34 right was infringed. The judge admitted in open court that he did not read the pleadings. And my lady, when it comes to the point of where is the authority that says you could have requested the transcript to say that to verify what actually happened at the agent court, my lady, you have that power. That power is in the inherent jurisdiction of the court to regulate this process, my lady. And this matter, my lady, is very serious, my lady. I said under oath, a judge did not read the papers filed on under oath. He said it in open court, my lady. You have the power to say, okay, you know what? I can't just apply the alternatively to applying the Evan Pascon rule, you could have just said to the registrar, you want the transcript of the proceedings, or even just the audio to listen for yourself if you doubted my affidavit, which legally is uncontested because there's no answering affidavit that was filed in the court. And my second part of the reply is that let me think. Oh, my lady, and the second part is that when your judgment makes a very, I would like to say, a dangerous error. It says that in the agent court, a judge may deal with the matter in the way he deems fit. My lady, I would like to clarify that. I would like to submit that that does not mean that a judge cannot read the papers. And this point is also in my replying affidavit. I explained it that the agent court is not a kangaroo court where the rules don't apply, especially rules of fairness, my lady. So what that means, it only means that a judge, my lady, can only what it means, he can say, I'm hearing this matter first, or I will hear it the following day. It does not mean he's allowed to not read the pleadings but still give orders, my lady. That's what I would like to clarify on that point. Yes, my lady. I think I've replied. Thank you.
Mr. Mathe, you say in your founding affidavit, or it could be your replying affidavit, that the court asked the respondent questions and the court asked you questions in the urgent court. The court had the papers in front of it. On what basis do you say that you weren't afforded a fair hearing?
Oh, yes, my lady. Thank you for that question. It actually helps me clarify this point. My lady, and I think I also made this submission at the hearing that we went to agent court, me and the respondent, and then the judge said to the respondent, tell me what the case is about. So what he did, he took my position as the applicant and made me a respondent, and also he took his job and made it their respondent's jobs. That's what I meant. Because, my lady, the applicant must tell the court why he brought the respondent to court. What happened at the agent court was that he said to the respondent, tell me why are you brought to court. That's improper, my lady. That's not how it goes. If that was the situation, my lady, even today, before we started this hearing, you would have just said, let's start now. The respondent, tell me what's your reply to the applicant's ground for appeal, and then we start from that point. It's improper, and, my lady, it's not compliant with the rules of fairness, my lady. The one who brings people to court must firstly explain to the court why he brought the respondent. That's his duty, my lady. So he took my duty and made it the respondent. And, my lady, that's not how things are done in our constitutional, my lady, in our constitution. And the second part is, my lady, I did make this part even at the hearing that what he actually did, he took the respondent and made them the applicant and made me a respondent, because now I was responding to what they already put in court. And, my lady,
Mr. Mathe, was he not asking questions of the parties? Did he not ask you questions? That is you say in your affidavit, I can't find the exact place, but you say in your affidavit that I understand he asked the respondent questions, but he then asked the applicant questions in relation to the application. Is that correct?
My lady, what is correct is that what he did, he said, respondent, tell me what the case is about. Address the court on the reason you are here. That's what he said. He said, respondent, address the court why you are here. And then they addressed him. And then he interrogated me to ask me this and that and that, and the things that he asked me are the things that were in the pleadings, and that if he had fairness in his conscience, he would have found them there, because it was actually improper. It actually not nice, my lady, that we draft affidavits and do a lot of research and come to court, and then when we come to court, the papers are not read. And my lady, and I like to believe, I don't think this is something normal that I think this is something out of the ordinary, that a judge does not read the papers. That's why I want this set aside, my lady. So what happened, he made me a respondent while I was the applicant.
Thank you. Is there anything further? Speak to me in response to Mr. Matidze's point that he made, that there are no constitutional issues raised in this application, and accordingly the buyer-watch principle does not apply. You're on mute, Mr. Mathe.
Oh, I apologize, my lady. My lady, the BioWatch principle applies because, my lady, when I made this rescission, I made it because my constitutional right in Section 34 was infringed by a judge. And the second part is that I was also exercising my constitutional right to remedy my constitutional right that was breached by a judge. And I was not frivolous, and so, my lady, I cannot be punished for that, my lady, and it's worse against the state, my lady. And the issue, of course, my lady, I think they generally follow cost. That is obvious, but my lady, in these circumstances, I was exercising a genuine infringement of my constitutional right, my lady. So the costs were not warranted, and I was also not asked by you, my lady, to address you on the issue of cost. And if you did, my lady, I would have submitted the BioWatch principle, because that's the issue. And the other issue is the rule of law, my lady. The rule of law is very important, my lady. We must all be held equal to the law. Either we are lawyers or judges or just laymen who want justice, my lady. So it's very important. And my lady, yes, I think that's it. Thank you.
Thank you. Judgment is reserved. The judgment will be published on case lines in due course. Thank you for everyone's appearance today. You are court is dismissed.
As the court, please. Thank you, my lady.
Thank you.
Thank you, my lady.